Hello, friends. Very good morning to one and all present here. Very warm welcome to my Business Laws channel. Today, friends, I'm going to start chapter number 2. Like chapter number 1, I will be talking about chapter number 2 in 3 to 4 lectures. In the first lecture, friends, I would like to cover offer and acceptance. So, what is offer and what are the essentials of valid offer? This I will cover. So, the term offer has been defined under Section 2A of the ICA 1872. When one person signifies to another his willingness to do or to abstain from doing with a view to obtain the assent of that other to such an act or abstinence, then he is said to make an offer. He said to make an offer. So, friends, there are 3 elements of valid offer. One is willingness has to be expressed by one to another. Second is, what is the main objective of the offerer? The main objective is to obtain the assent of that other person. Now, assent is obtained regarding what? To do something or to abstain from doing something. So, friends, I have talked about elements of the offer, which is very clear from the definition which is given under section 2A. Now, friends, I would like to talk about what constitutes valid offer. What are the essentials of valid offer? The very first point is willingness of the offer must be conveyed. So, this point is very clear to all of you because it is given in the very first line of the definition. Second is, offer must be made with the intention of obtaining the assent. This is also a very clear point. That why is offer made? The offer is made with the intention of getting the assent of the other person. The person who makes an offer is known as offerer, and the person to whom the offer is made is known as offeree. Now, next point is, friends, point number 3, which is offer must give rise to legal relation. So, offer must give rise to legal relation. Now, offer may give rise to legal relation or religious relation or moral relation. Only that offer which gives rise to the legal relations, that is known as valid offer. So, Balfour versus Balfour is a very important case law regarding this. Now, point number 4 is offer terms must be definite, unambiguous, and not loose. Terms of the offer must be very clear, very definite. They must be definite and very clear. They should not be vague or loose. Say, for instance, he has bought horse and he says, this horse turns out to be lucky for me, then I will come and buy another horse. So here the terms are not certain. They are very loose or vague. Now, next point is point number 5. Offer may be general or specific. So, friends, offer may be general or specific. Now, when the offer is made to a particular person, it is known as specific offer. When the offer is made to the world at large, then it is known as general offer. So, specific offer example is when A makes an offer to B to sell his laptop for 30,000 rupees. It means this is the example of specific offer because offer has been made by A to B. Now, in this case, it is B only who has to accept this offer. So now, general offer, a very important case law regarding the general offer is, friends, Carlyle versus Carbolic Smoke Ball Company. In this case, Carbolic Smoke Ball Company used to produce certain sort of balls, medicine which used to cure influenza. Now, Carlyle was a lady who made the use of the smoke balls produced by the company as per the directions given by the company. Even then suffered from influenza because company said in the advertisement, anybody making the use of our balls as per directions given by us still suffers from influenza will be given fixed amount of reward. And apart from this 1,000 pounds, it was also deposited by the company to secure the payment. Now, what happened? Carlyle made the use of medicines as per the directions given by the company and still suffered from influenza. And it was held in the court of law. When she filed a suit against, she talked to the company refused to make the payment, saying as no time period was specified, so we are not going to give you the payment. Then she filed a suit against the company in the court of law, and the decision given in the court was that Carlyle was entitled to recover this amount of reward from the company. So friends, remember here the general offer is of continuing nature. If like Carlyle, there are 10 persons who have made the use of medicine as per the directions given by the company, and even then suffers from influenza, then each one of the 10 persons will be given this fixed amount of reward which was declared by the company. So friends, I have talked about general and specific offer. Now moving ahead, the next point is offer may be express or implied. Now there are various types of offer. Now offer may be express or implied. This is also one of the types of offer. Express means, offer is express. That is either, it is made by words, verbal or written. And when we talk about implied is always implied from the conduct of the parties or from the circumstances of the case. Now, examples of implied offer: DTC buses and metros plying or operating at different routes. This is one of the examples of implied offer. Then weighing machines, ATMs, they are more examples of implied offer. Now, point number 7 is offer may be positive or negative. Any offer which is made by one person to another to some act is known as positive. And if it is to abstain from doing something, then it is known as negative offer. So, A is a chain smoker, and B says to A that you give up this smoking, I'll pay you 15,000 rupees. This is the example of negative offer because A is being abstained by B person. He will not go for smoking for this, so he gives up. He decides to give up smoking, and then friends, we will have to pay that fixed amount which he promised to pay to A person. Next is offer may be definite or standing. Now, if the offer is for definite quantity of goods, that is for 10 computers, 15 computers, 2 cars or 10 cars, then offer is known as definite offer. But if the offer is not confined to definite quantity of goods, it extends to a series of transactions, then it is known as open offer, which is also known as standing offer or continuous offer. So in case of standing or continuous or open offer, the moment the buyer makes a contract, then in that case, buyer places the order, the contract is created. Point number 9 is offer must be communicated. It's a very important essential of valid offer, that offer must be communicated. Now there is a leading case law regarding this, that which is Lalman Shukla versus Gauridutt. Lalman Shukla was plaintiff. He was a servant of Gauridutt and Gauridutt was master or defendant. Gauridutt lost his nephew. He made advertisement in the newspaper or after he told his servant to find out his nephew, missing nephew. After his servant had left, he distributed pamphlets saying that I have lost my nephew. Whosoever is able to find my nephew will be given fixed amount of reward, which was rupees 501. And fortunately, servant was able to trace that missing boy. And now he came to know that some reward was announced by his master. So he filed a suit against the master for the recovery of this reward amount. And it was held in the court of law since servant had no knowledge of the offer. because offer was not communicated to him. So it was held in the court of law that he was not entitled to recover this amount from his master. That is, the person should have the knowledge of the offer. If offer is not communicated, then it will not be termed as valid. The next point is, offer should not contain the terms, the non-compliance of which would amount to acceptance. Now, if say A wants to sell his car to B, Honda City car to B person for 3 lakh rupees. And A says to B that if you do not give your reply by coming Monday, then I shall presume that you have accepted the offer. So here, friends, the offer is containing the terms, the non-compliance of which would amount to acceptance. Such terms should not be contained in the offer. Now coming to the next point, which is point number 11, which is terms and conditions must be communicated. Now, if the terms and conditions are not communicated, then that offer will never constitute valid offer. So friends, we are all customers. You go to the market, say you have given the clause for dry cleaning purposes. Then you get receipt. At the bottom of the receipt or at the back of the receipt, some conditions are laid down. Say if the clothes get destroyed through fire or they are stolen, then dry cleaner will be responsible to what extent. So these conditions are laid down. If conditions are laid down at the bottom or at the back of the receipt, then they will be binding upon the customer. And if these conditions are not laid down and the goods get destroyed due to fire or they are stolen, then the dry cleaner will have to compensate the customer 100% for the loss. So all terms and conditions should also be communicated. Then point number 12 is two identical cross offers does not create a contract. Two identical cross offers do not make a contract. So now the question arises, what is the meaning of cross offers? Cross offers means, friends, two identical offers which are made by two persons to each other in ignorance of each other's offer. Say for example, A has sent the letter to B to sell his Honda City car for 3 lakh rupees, and B has also sent the letter to A to buy this Honda City car for 3,000 rupees, 3 lakh rupees. So friends, here both the offers are identical. Both parties do not know that other person is sending the offer. So one is the offer to buy, other is the offer to sell. Where is acceptance? So here, friends, these are two identical cross offers. So these will not make a contract. These will not create a contract. Now, next point is 13th point, which is offer is different from an answer to a question, and it is also different from an invitation to an offer. So offer is also different from an answer to a question. Say somebody has posed a question to other person, which is answered by the other person. Then it will not amount to offer. Say B wants to buy WagonR car from A. He says, will you sell your WagonR car? A says, yes. Then it does not mean, friends, that A has made the offer to B person. So here, because A has answered the question which was posed by B person. Now, offer is not only different from an answer to a question, but offer is also different from an invitation to an offer. Now, the question arises, what is the meaning of invitation to an offer? Now, here the offer is being invited. Take the example of prospectus. When the company issues a prospectus, then in that case, the company is inviting the offer from the public. Issue of prospectus is the example of invitation to an offer. But when investors, they read the advertisement, make up their mind, they apply for shares, then, they make the offer. And if they are allotted the shares by the company, it means the offer which is made by them has been accepted by the company. So friends, you should be very clear regarding this, that offer is different from an answer to a question, and it is also different from an invitation to an offer. This question is very, very important from examination point of view, that what is offer, what do you understand by the term offer, and what are the essentials of valid offer. So friends, the answer for this question, you will have to define the term offer, which is defined under section 2A of ICA 1872, and then you have to write all these 13 points along with explanation and case laws or examples. So it is all about this lecture heading today, which was offer, meaning and essentials. Friends, I hope you will like this content. To like and subscribe to my channel, and do press on the bell icon so that you can get the notifications in the future period and whenever I post my videos. Okay friends, goodbye, take care.